Love is the power that holds us together and is at the center of our shared values. One of our Unitarian Universalist core values is equity. We declare that every person is inherently worthy and has the right to flourish with dignity, love, and compassion. We believe and understand that it is ours to do, to use our time, wisdom, attention, and money to build and sustain fully accessible and inclusive communities where every person can flourish with inherent dignity and worthiness. This is the ideal, something to strive for. But what do these words really mean? Let us define equity as being equivalent with others, that you are treated the same as someone else who is similarly situated. If you're a woman and you do the same work as a male co-worker, you should be paid the same amount of money. That was a Lucy Ledbetter case that became a statute. But in fact, we know women as a group receive less pay than men. If you have certain credentials and you apply to a school, should you be treated the same based on your credentials as others of a different sex or race? There were a series of cases on affirmative action, Bakke and others, that I'll be discussing. Do people really have the same opportunities? How does that work in a practical manner when a society disperses limited opportunities such as admission to college, medical school, or law school? Everyone has a spark, but not everyone gets into Harvard or Michigan or the University of Houston or gets a certain job. So what are the real life choices and questions? Who gets the job, a seat in medical school, a slot at Michigan or Michigan Law School, or at Harvard or at the University of North Carolina? Let's look at some historical and recent legal examples. So first, a story from history, which I personally find fascinating. It comes from a book. Alan Taylor, a Pulitzer Prize-winning historian, wrote a book called American Colonies, The Settlement of North America. In it, he traced the settling and development of the early American colonies. As many people know, different religious groups and nationalities settled the various colonies, often fleeing Europe to the United States to escape economic, religious, and other persecution, which they continue to do so today with more or less success. As a side note, we acknowledge that America was not an empty canvas and was populated by millions of Native Americans, but that's a discussion for a different day. So for example, the Spanish first settled in Florida, Dutch and Swedes to the middle colonies. The English went first to New England and to the Chesapeake areas. Most English colonies allowed slavery with all of its attendant horrible aspects. During the early 1700s, Georgia was founded, named after King George. This was a time when London philanthropists and social reformers led by James Oglethorpe, a landed gentleman and member of Parliament, set up Georgia and hoped to alleviate the English urban poverty by shipping quote, miserable wretches, unquote, to a new southern colony where they would work hard on their own small farms, and therefore they would cure their perceived laziness. The same time about that they were sending criminals to Australia. The Georgia trustees wanted a colony of yeoman free farmers working on small plots of land. Interestingly, they also prohibited rum drinking, an elected assembly, and lawyers. The settlers arrived and found a hot, humid environment, and they struggled, especially in comparison to the Carolinas to their north, which did allow slavery on large plantations. The residents of Georgia appealed these restrictions, and the bans on rum drinking, an elected assembly, or basically democracy, and lawyers were progressively dropped. The Georgian dissidents then rallied behind a slogan, quote, liberty and property without restriction, unquote. They petitioned London, linking their freedom, their equity, with other colonists who had the right to enslave others, like their neighbors in South Carolina. Basically, they wanted and asked for equity or freedom, the right to enslave others. You can't make this up. You also can't predict how a present view will be perceived in the future and a present concept defined. Very clearly, allowing slavery is not equity. Georgians were allowed their equity or freedom, namely slavery. The eventual result was a plantation system with concentrated wealth and power for a few individuals. Does this sound a bit familiar? A second historical example in the Declaration of Independence, the second sentence says, "We hold these truths to be self-evident, that all men are created equal, and they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness." Thomas Jefferson wrote most of this. If you've looked at the history, after he wrote it, he sat at a table and they went through it word by word, and everybody else changed and edited what he had written. He wrote the original and it was edited by his colleagues. He was also a slave owner. When he said all men are created equal, he wasn't saying all citizens get a house like his mansion in Monticello. He was saying all people should have the opportunity to strive, to make choices about what they want to do. Discrimination is viewed as the opposite of equality. The Equal Protection Clause prohibits discrimination on certain bases: race, sex, disability, or age. If you're discriminating, you're not treating people equally. I want to briefly discuss some three major Supreme Court cases on discrimination in higher education and how the law evolved. Interestingly, the cases correspond with my legal career. Making decisions based on race, sex, disability, or age generally is highly suspect and has to pass a strict scrutiny standard. There must be a compelling government interest to allow it to be used. These cases are about allocating resources or opportunities, respectfully, admission to college, med school, or law school. The basis or preference on the basis of race or sex was in response to a well-documented long history of unfair treatment of those same groups. In 1978, I was in my first year of law school, and there was the Bakke decision. Bakke, a white male applicant, was rejected from med school at the University of California, and he found out that he had better credentials than some African American women who were admitted to medical school under a quota system. This was one of the first early affirmative action cases. The court stated you cannot have a quota, but you can consider race as a part of a series of concerns. Cases discuss exposing students to different viewpoints and also allowing it to remedy discrimination. In 2003, 25 years later, while I was in the middle of my career, which included 30 years investigating discrimination on the basis of race, sex, disability, and age for the U.S. Department of Education, Chicago office, the Supreme Court reviewed two Michigan, it's called the Grutter cases, involving admission to the college generally or to law school. In one, the plaintiff who was refused admission to the law school was a white female with very high scores. The court found, with respect to undergraduate education, race was the determinative factor. With law school admission, race was just considered as one of a series of factors. The court said the use of an applicant's race is one of the series of factors in an admission policy of a public education institution does not violate the Equal Protection Clause if the policy is narrowly tailored to the compelling interests of promoting a diverse student body, and if it uses a holistic process to evaluate each applicant as opposed to a quota system. It also limited such use to 25 years, saying we expect that 25 years from now, the use of a racial preference will no longer be necessary. With respect to undergraduate admission in the second case, the court said the admission system used race as the determining factor and was not allowed. Sandra Day O'Connor wrote the main decisions and was a key vote. She's one of the heroes of this story. She was a moderate Republican and the first female Supreme Court justice. She was born in 1930 in El Paso. She grew up on a large ranch in Arizona. It was 9 miles from the nearest paved road, and it lacked running water and electricity until she was 7. She owned a rifle, began driving when she could see over the wheel, and learned to change a flat tire. She was independent and did well in school. She attended Stanford at age 16. She went on to Stanford Law School, a top law school, graduating near the top of her class. Future Supreme Court William Rehnquist was her classmate. When she graduated from Stanford, she could not get a job as an attorney. She first got a job as a clerk, then she got a volunteer job position, and finally a paying job as an attorney. She later became state legislator, first female state Senate majority leader, judge, and finally Supreme Court justice. She was approved for the court unanimously. Again, a difference from today. As a moderate, her vote was often the determining one. They called it the Rehnquist Court, but they almost called it the Sandra Day O'Connor Court, because her vote was the key vote, the one that would determine whether or not a case would go one way or another. As a moderate, her vote was often the determining one. In her decision in these cases, she allowed sex to be considered as a factor under certain circumstances described above. I retired in the fall of 2019. They've recently closed our office, which covered about 6, 7, 8 states in the Midwest. On June 29, 2023, in the Harvard and UNC, University of North Carolina cases, the Supreme Court decided the time had come to end affirmative action. It was 20 years later. There was no end in sight otherwise. The Supreme Court has had a well-documented aversion to race, sex, disability, or age-based decisions that violate the Equal Protection Clause. Basically, if you were applying for a job, you shouldn't get the job or the slot based on you being black or white, or your age, or being male or female. In general, do questions remain? So when a government offers opportunities, how do they do it fairly? Who are you compared with? Are you compared with the person who has lower credentials? Are you compared to the group of people who've had historical deprivations? How do you look at a person who has worse credentials but their group was underrepresented and they can present a different perspective or experience to other students? What about recent cases where recent Asian immigrants are not admitted to Harvard while legacies, who are children of graduates and often white, are? Given the long history of inequities in America, based especially on race and sex, is it fair to prohibit such preferences based on race or sex? In general, equity means an opportunity to pursue your choices, to emphasize family or work, to retire early, move to Texas, and take care of your grandchildren. If you choose to, pursue your interests or choices freely and fairly with dignity, love, and compassion. I suggest to you that the main point is that equity, or how a person defines equity, depends on the person's perspective and what choices they have and make, as long as they don't hurt anyone else. This is the third time I've delivered a sermon at the fellowship. I said in 6 years. Sherry looked it up and said 4 years. And as usual, she's right. In the introduction, Sherry noted that I worked for 30 years in the Department of Education Office for Civil Rights. I didn't think I would get so upset. As noted, my office was recently closed. I've really struggled with this sermon, given recent circumstances in our world at large, and given the long history of discrimination, especially based on race and sex, and how they limit options and opportunities. I don't think that if you suddenly change the rules and say we're not going to discriminate anymore, that you're going to suddenly make things equal and allow people an equal chance for the benefits of society. I don't agree that the law, that affirmative action is illegal or inappropriate. I don't agree that that's the way it should be. And I also think about my major choices to work for the government for 30 years, to be more available for my family than someone in private practice and provide family health insurance. To marry Sherry, the best decision I ever made, and as I noted, to retire early and move to Texas, which I had never even visited before my son moved here, and take care of children.